Let's get started. And once again, welcome. And thanks for joining today's session addressing the cash flow issues of your clients, beneficiaries, and even your firm, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. Mark will address questions after the presentation. If your question is case specific and confidential, please indicate that in the chat and someone will respond separately after this presentation. Our presenter today is a professional with extensive experience in the probate field. Marc Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Marc is also a member of the Florida Bar's Real Property, Probate, and Trust Law section. Marc has been working in the specialty finance industry for over 25 years and involved in purchasing over $100 million worth of assets. Most of those purchases, pursuant to various state laws, require court hearings, many of which Marc has either attended or appeared as counsel. As the CEO of ProbateCash, Mark is now spearheading a relatively new industry of purchasing interest in actively pending inheritance claims from estates or trusts. So now, without further ado, let's hear from Mark. Mark, can you start us off with what ProbateCash does?
I can, and thank you, Molly, and good afternoon, everyone. I think we have about 100 lawyers, mostly lawyers, who have tuned in from around the country. So always good to meet new people and hopefully provide some new information to you guys. What does Probate Cash do? That's what you asked. Probate Cash advances beneficiaries upfront money while beneficiaries are waiting for their inheritance that's tied up in the probate courts. I've spent much of my career providing liquidity to people who are entitled to future cash flows, but don't have the ability to access that cash flow at the present time. So, as most everyone on this webinar can attest to, and have likely fielded repeated phone calls from frustrated ears, access to an inheritance falls very neatly into such a category. So, people unfamiliar with probate probably believe, like most people, what they've seen on TV, right? So, loved ones or not so loved ones pass away, and the family gathers in the lawyer's office for the reading of the will. Sometimes there's not a will, but for TV purposes, there's always a will. The
Mhm.
happy family members here, they're getting mansions, they're getting money, sports cars, and the jaded people are walking away unsatisfied. What most people don't know, and often learn right before calling your office or my office, is the probate process, and they find that out usually because they went to the bank to try to access a bank account of the decedent, and the bank says, "Sorry, son or daughter, you are not entitled to this money, or I can't even tell you whether you're entitled to it because you are not the legal representative of the estate." What does that mean? Call a probate lawyer. Or they try to sell a piece of property. So let me see your letters. No, no letters. They don't know what that means. They call the probate law firms, right? So after talking with you, they finally understand that probate's going to take some time. Reality rears its ugly head. Property taxes have to be paid, right? Repairs made to houses, bills coming in. Beneficiaries who are counting on their inheritance to meet just the regular obligations suddenly can't do so. That's the void that probate cash fills. So we provide a portion of the heir's inheritance up front in the form of a non-recourse advance, and we'll wait until the estate assets can be distributed from the probate court before being repaid.
Okay, but how does an advance from ProbateCash work?
Okay, so how does it work? You find somebody who needs an advance. We can talk directly to the beneficiary who needs the advance, or we can talk with you as well if you represent that beneficiary. We're going to talk to you anyway because we'd like to know as much as possible about the estate. We'll have the assigning beneficiary complete a simple application form about them and the estate, and we can often fund the advance to them within 1 to 2 business days. So we have underwriters here who review the case that's already been filed, provided the case has been filed, and again, confirm some information with you, estate attorney. The goal of an advance really is to provide necessary liquidity to the beneficiary while also keeping the beneficiary engaged in seeing the final result from the probate case. In other words, we're not going to purchase the entire inheritance. In fact, depending on the status of the probate case, we may just purchase a small portion of the inheritance. For example, if the claims period hasn't expired, or if there's litigation, we'll still provide an advance, but it'll be a modest advance. If the case is close to its final distribution and we understand exactly what beneficiaries are going to receive, we can provide a much larger advance. Our average advance amount is over $10,000, but we'll advance as small as $3,000, and we'll advance as we've advanced as much as $500,000.
But how can ProbateCash fund an advance so quickly?
Well, so we're not a bank, right? So I've explained what Probate Cash does. So let me explain what Probate Cash does not do. We're not lenders. We do not provide loans. We don't charge an interest rate. We don't do a credit check. We don't take collateral. Our advances have none of the characteristics that you would see in a loan. Because they're non-recourse, if the heir cannot repay us at the end because there were insufficient assets to pay us, the inheritance was reduced because a home didn't sell for as much money, a claim was made that wiped out the inheritance for the beneficiary. Those are our risk. Litigation, like a will being challenged, that's our risk. The only time that we have recourse is if the beneficiary materially breaches our contract, commits fraud, actually receives the inheritance, but forgets to pay us. That's obviously just stealing.
Right. But how does an advance to one beneficiary affect other beneficiaries who are not assigning portions of their inheritance? And it's a two-part question. So, and also, how does an advance affect the probate case?
Sure, excuse me. So often, of course, but the estates are made of more than one beneficiary. One beneficiary wants to assign a portion of their inheritance because they need money for personal reasons. Maybe they're not the personal representative. They're not looking to fix up the home or pay taxes. They're just want money. They just want access to their inheritance for whatever their reasons are. We enter into contract just with that beneficiary to purchase a portion of their inheritance. That contract does not affect any of the other beneficiaries who aren't assigning their inheritance. It doesn't affect the personal representative. It does not affect the law firm. So there is no effect, basically. Not on the beneficiary, other beneficiaries, and not on you as a lawyer looking to close the case. However, what we do is we file the assignment of the inheritance with the probate court. So if a beneficiary is assigning, let's say, $20,000 of their inheritance, they will have signed an assignment agreement that we file with the court that advises the personal representative, it advises the judge, you as a state attorney, any interested party, that they have assigned $20,000 of their inheritance to probate cash. And when the estate assets are distributed, the personal representative knows to pay the $20,000 of that person's inheritance to us. If for some reason, again, that their inheritance is insufficient to pay us the whole $20,000, we do not look to the other beneficiaries. We don't look to the probate attorney. That's just one of our risks.
Okay, but and how can a probate cash help law firms?
Okay, so that's probably why you guys are here. Um, Probate cash, number one, how does it help a law firm? I know from talking to probate attorneys, being an attorney myself, beneficiaries of estates, probably not even your clients, just the beneficiaries, are calling you saying, when am I going to get paid? I really need money. Why is this taking so long? No matter what answer you provide them, they're not going to understand. It's still taking a long time. You can refer those people to us. We will advance the money against their inheritance. That gives them the breathing room they need to have cash now, accessing their inheritance. It gives your firm breathing room to not have to repeatedly field their phone calls. And we'll also stay in touch with them and we can give them status reports of what's going on in the estate, which also gives the personal representative breathing room. So we know how these work. We know beneficiaries often don't even get the information they want. They're not always getting the clear information from the personal representative. They they can only call the law firm so much. So we step in, we can help them out, give them the status of how things are going, manage their expectations. Second, as we got into this business, we realized that many of probate attorneys and law firms were turning down business, not because they wanted to turn down business, but because the people applying for the letters could not afford to pay a retainer fee or to cover the cost. And so firms are saying, well, I don't want to cover that. I'm not going to take that risk, or we can't afford it. We need the cash flow. So we realized that was becoming a problem, and we started to say, okay, there's another void for probate cash to fill. So what we've done is when people are looking to retain probate firms for the purpose of opening up the probate, provided they have some real property that's going to be sold or some assets that are there, we will enter into an agreement with the beneficiary or the anticipated beneficiary, usually the anticipated personal representative, in fact. We will provide an advance to that person. they will authorize us to pay that advance directly to your law firm for the purpose of a retainer fee and cost. And so now your firm, number one, is not turned down business, and number two, actually has the retainer fee up front. And of course, for us, there's often times where they need further advances for whatever purpose as the probate goes down the line. As I mentioned, as each probate goes through the different stages, petition filed and creditors' claims, we can keep giving more advances if one or more beneficiaries want to. But what's important, and I'm happy to be able to share this today, is that probate attorneys from around the country need to understand that this is yet another tool that they can offer. So if you have a client also who needs money, doesn't understand how long it takes to get their inheritance, the probate case to proceed until they've talked with you, but they need money for something very necessary. It could be anything, medical or just a vacation. You, the attorney, now are in a position to say, well, I know a firm that may be able to help you get some of that money up front. You're now offering something that other probate attorneys may not know about. It'll stop them from continuing to shop to go down the street to the next probate attorney. And so now you have offered a potentially new client with new resources to come to ProbateCash for money up front. Number two, may be able to get your own retainer and cost paid up front. And so that's for new cases. For old cases, stop the phone ringing from beneficiaries looking to see what's going on and when they're going to get their money. Those are three significant areas where I think the ProbateCash can give a very positive assist to your law firm.
I could see how that would be beneficial for sure. But are there any laws that govern inheritance advances?
Okay, so it's a new field, relatively new field. With that said, there is a state that has a law that governs inheritance assignments. I mean, exactly what we do. It's California, has that probate code. It's for those keeping score at home. It's probate section 11604.5. 11604.5. That's the California statute. As you can imagine, there are a lot of consumer protections in that statute, and we love it. It makes it very clear. In fact, we file, as I said we do, we file our assignments with the probate court, the beneficiary's assignment. And in California, it takes a step further. The estate attorney is actually required by law to include ProbateCash in the petition for final distribution and then the order for final distribution. So the personal representative knows to pay ProbateCash its assignments. Illinois is another state that has a court order process. And Illinois, therefore, because of the court order process, where some counties, but not all, but Cook County is one of them, requires a court order approving our advance to the beneficiary before we're allowed to pay that advance. So it can take a couple of weeks before we can pay the advance in Illinois and some of the counties there. But again, what we do is we follow the California statute in spirit and mostly by letter in all the other states. Transparency is very important to us. Consumer protection is very important because it just makes it much cleaner at the end of the process to get paid. Everybody knows that we have to get paid. And as another belt and suspenders operation, and maybe it is the attorney and me, before we make advances to beneficiaries, we also conduct a recorded phone call with the beneficiary where we go over the terms of the advance and the repayment terms of the advance. And that's a recorded call that we keep just in case the beneficiary forgets they received the advance later on down the line. So that's what we do, just using pretty much California's state statute, and we kind of use that as our own model legislation around the country.
Yeah, you cover your bases. Well, thank you, Mark. If you can believe it, we're already at that 15-minute mark. And as promised, Mark will stay on to answer your questions. If you need to leave now, we'll send everyone a link to the recording of this presentation and the questions and answers. But let's first get to some of these questions. Looks like the first one is, as an attorney for the estate, can I be held responsible if I talk to your company about an advance or if you don't get repaid? And also, how can I leverage ProbateCash to sign a client?
Okay, so I don't think you could be at all liable or be held responsible about anything just having a conversation with us. But what we do is we are again we're in contract privity with the beneficiary. This is totally up to the beneficiary to do a transaction. If they like the terms, they can do it. If they don't like the terms, they don't have to do it. They it's up to them. You're simply referring us as an option, just like you may refer somebody to a junk removal company or an auctioneer, so anything like that. So it's just another option for you guys. And again, leveraging us to sign a client, I think again went over a little bit. Just you can certainly tell your potential client about our services, and if they sign with you, the referral to us, so they can actually access their inheritance up front and not have to wait the 6 months to a year more before the probate closes.
Great. And we have another question here. It says, what if the probate is in a trust? Can probate cash still provide an advance to the beneficiaries?
Yes, absolutely. So if a trust is the beneficiary and they're beneficiaries of the trust, we can do that either by the trust assigning a portion of its inheritance. If it's a small trust with maybe only one beneficiary, two beneficiaries, the trustee could be entering into the contract with us. Or if the trustee agrees to pay us, pay probate cash back, the assignment of the beneficial interest in the trust that the beneficiary would be able to receive, we will proceed in that manner.
Okay. Following that, we have a question that says, does the executor have to approve in advance?
The executor does not have to approve the advance. In fact, we often don't talk to the executor. We do file the assignment. We do talk to the estate attorney, so the executor usually ends up knowing about the advance. We know, I'm sure you know, that there's occasionally conflict between the personal representative and the other beneficiaries. Sometimes they're not always talking to one another, which is why the beneficiaries are constantly reaching out to your office or reaching out to us. The short answer is no, we do not need authorization from the personal representative to proceed. We can still do the transaction with the beneficiary, but we will be looking to the personal representative to pay us back from the assigning beneficiary's inheritance what is owed to us.
Okay, great. I want to make sure we got everyone's questions. And it looks like we did. Now, if you're like me and you think of your question 15 minutes later or tomorrow, please feel free to reach out to us. I'm going to give you Mark's contact information here in a second. We'll also be sending out a follow-up email with the e-brochure for Probate Cash and a link to this webinar. So let me get you Mark's contact information. You can call Mark at 561-476-0018, or you can email him at Mark, and that's MARC, at probatecash.com. And thank you so much for joining us today, and have a great day.
Thank you.